Good morning. Thank you for having me. My name is Nina Salarno. I'm the president of Crime Victims United. I bring to this panel a very unique perspective. Not only am I a former prosecutor, I was the very first state director of the Office of Victim Services and implemented the death penalty notification program for victims. I, too, am a murder victim. My sister Katina Salarno was murdered execution style at the University of Pacific. And while I sympathize with Ms. Webb, I bring to this panel, like I said, a very unique knowledge. Ms. Webb is courageous for her testimony. However, she is not the representative of the victims. When I was the director of the Office of Victim Services and as the president of Crime Victims United, I had personal contact with almost every victim associated with those whose inmates were condemned to death. All of them. It is not hatred, and I would like to correct this panel on that. All of them want justice. Seeking a death penalty is justice for victims. It is not hatred. And I bring to you what the death penalty really does do. I was intimately involved in the execution of Darrell Keith Rich, a man who in 1979 sexually assaulted 11 women, brutally murdering 9 of them, including a 12-year-old child that he threw off a 101-foot bridge and let her bleed to death over 24 hours. As I walked out of the execution chamber that night with the rape victim, the surviving rape victim, whose head had been smashed and disfigured by a rock, she said, "Thank you." And I said, "For what?" "For the first time, I will sleep tonight because I will not worry that a court, a governor, or anyone will overturn this sentence and he will be released and finish his job." And as to your point, has anybody ever been released off death row? Yes. Robert Lee Massey was a man who murdered an elderly couple in Orange County, was sentenced to death, and under the Rosebud Court had his sentence commuted to life without parole, then commuted again to life with parole, was released to San Francisco County, and murdered a father of 5 7 months later. Effectively, if this were to pass, it is not automatic that each and every one of these inmates will serve life without parole. To answer the panel's question, what then happens is they get a resentencing hearing where they get to challenge the very circumstances that let them, that a jury decided were heinous enough to sentence them to death. So in effect, you're not only putting the victims through a second trial, you are allowing them to then be tortured, as my family is, because the murder of my sister, because circumstances were different, got life with parole, and we are now facing, in July 13th, our 10th parole hearing. There is nothing more onerous for a victim of crime than to deal with the possibility that the murderer of their loved one will be paroled. For these families, even though it's taking a long time for justice to come to them, knowing that the person cannot be paroled, knowing that they do not go through a resentencing hearing, is a sense of peace. And to take away the ultimate justice and peace that they deserve, that is incorrect. And each of these victims had the ability to voice. I would also point out that this amendment is unconstitutional. This state overwhelmingly in 2008 passed Marsy's Law. Marsy's Law implemented 2 things, a truth in sentencing and the right for the victim to be heard before any inmate is resentenced for the sentence that they are serving. There is nothing in this initiative that provides for that provision. There is nothing in this initiative that provides that the victim will be heard if and when this passes and they are resentenced. There is no provision for that. That makes this unconstitutional. This is usurping what the people of California voted in overwhelmingly when they voted in Marsy's Law. Also, it does not cut down on the number of trials. It still provides there has to be a penalty phase for those who are going to be sentenced to life without parole. They still have to go through 2 trials, just like we do in the death penalty phases. The other thing it does back on Marsy's Law is it takes away the victim's right to be heard if they are willing to agree to a lesser plea bargain. Obviously, the death sentence is the ultimate. If you take that away, then life without the possibility of parole becomes the ultimate sentence. Therefore, the victim has really no way to voice, well, maybe instead of death, our family will agree to life without possibility of parole. You're taking away their right, their constitutional right, to be heard. And last, I would point out to you, money does not replace anything. Let me explain to you as a victim who has lived 36 years without her sister, who has watched my parents suffer after parole hearing to parole hearing. The fact that you're saying we're going to up it from 50% to 60% means nothing to victims to crime, because all the inmate has to do is keep their books below 60%, and there is no restitution paid. And I do find this as a side note that the initiative directs the savings to the general fund instead of the victim restitution fund. So I believe this was done without thought for the victims. And again, as I said, I sympathize with Ms. Webb. I know what it's like to bury a sister. I also know what it's like to relive that murder every 1 to 5 years, because I sit through each and every parole hearing. For those victims associated with the condemned, you are giving them the ultimate sense of peace. Whether or not they die on death row of natural causes or they are actually executed, you are still allowing that victim to live in peace. And I ask, this initiative takes that away, and most importantly, it takes away their constitutional rights. Thank you.
Thank you. Next.